let's talk about how your firearm can be confiscated in Kansas, and most importantly, how you can legally get it back if that ever happens. Kansas is known for having strong Second Amendment protections, but even here, law enforcement can temporarily take possession of your firearm. Let's break down the most common scenarios for firearm confiscation in Kansas. Reasons include domestic violence arrests, court-issued protection from abuse orders, and firearms seized as evidence in criminal investigations. Confiscation can also occur due to illegal possession by a prohibited person, during mental health welfare checks, or if a gun is used in a crime. Before we go deeper, make sure to like, subscribe, and hit that notification bell so you don't miss any future breakdowns here on The Right Slant. Kansas has no state-level firearm registration or extreme risk red flag law, which limits the circumstances under which the government can take a gun. However, confiscations do happen, particularly under protection from abuse orders, or PFAs. Kansas statutes annotated 60 to 3107 allows judges to issue PFA orders that can require firearms to be surrendered, often in domestic violence situations. Under Case A 22 to 2512, law enforcement may seize weapons incident to arrest or when the firearm is evidence of a crime. Kansas law requires police to keep a detailed record of all seized property and make it available to the court. Federal law bars certain individuals from possessing firearms, such as convicted felons or those convicted of domestic battery. If police discover a prohibited possessor, guns may be seized, and Kansas state law aligns with these federal restrictions. If someone is transported for involuntary mental health evaluation under Case A 59 to 2953, law enforcement may temporarily secure firearms for safety. These seizures are not automatic forfeitures. The owner must simply be legally eligible to possess firearms for them to be returned. Kansas requires that seized property be returned unless the court orders otherwise or possession would be illegal. This comes directly from Case A 22 to 2512, stating property must be returned once no longer needed as evidence and the owner is legally allowed to possess it. Step 1. Determine why the gun was taken, whether it was evidence, part of a PFA, due to arrest, or a mental health intervention. Step 2. Check case status or court orders. If the seizure involved a criminal case or PFA, your firearm cannot be returned until the case is dismissed, you are acquitted, or the court releases the property. Kansas courts notify police when seized property is to be released, but if a judge explicitly ordered you not to possess firearms, it will not be released until that order is removed. Step 3. Contact the Law Enforcement Evidence Division. You'll need photo ID, the case number, proof of ownership, and a background check confirming legal eligibility. Most departments in Kansas will not release firearms without a background check to comply with federal law. Step 4. Pass the eligibility verification. Law enforcement must ensure you are not prohibited from possessing firearms. They will check for felony convictions, domestic battery, active PFAs, mental health prohibitions, and federal disqualifiers. Step 5. The firearm is released if you are legally allowed to possess it. The gun is not needed as evidence, and no court order prohibits its return. From a conservative perspective, it's important for Kansans to understand that while the state is gun-friendly, federal restrictions still apply. You will not get your gun back if you are convicted of domestic battery, become a prohibited possessor under federal law, or if the firearm is determined to be contraband. Other reasons include if it was used in a felony, a judge permanently prohibits possession, or you cannot prove ownership. If law enforcement refuses to return your firearm, Kansas allows you to petition the district court for a hearing under Case A 22 to 2512. The judge can order the police to release the firearm if you are the lawful owner, legally eligible, and the gun is not needed as evidence. Kansas remains one of the most protective states for Second Amendment rights, but that doesn't mean your firearm can never be taken. The key is knowing your rights, the legal process, and the exact steps required to get your gun back. If you found this helpful, make sure you like, subscribe, and hit that notification bell so you never miss another breakdown here on The Right Slant.